Good morning, friends. I am today discussing important case law relating to recovery of possession and the behavior of the Honorable High Courts in defending their junior judiciary. All is discussed in this case, so be settled and listen this video attentively. And if you feel that there is quite some improvement, you are free to criticize my video. I have no objection for that. The case lies Mahavir Prasad Singh versus Jax Aviation Private Limited, that is of 1998, and this was presided over by Honorable Justices Shahid Sagir Ahmed and Katie Thomas. In this case, the section involved are 151 of the CPC 1908 as well as Section 24 and Section 115 of the Code of Civil Procedure. If you want to read full judgment, you can go to equivalent citation, that is Manu SC 0706 of 1998. Friend, this is a recovery suit and a civil suit for recovery of possession of building was filed by the appellant in the court of Additional District Judge Tisajari, Delhi, which was presided over by respected Shri S.N. Dhingraj. Respondent filed written statement in the suit taking advantage of certain admissions made in the written statement. Appellant preferred an application under Order 12, Rule 6 of the CPC for pronouncing a judgment having regard to such admissions and for passing a degree for recovery of possession of the suit premises. Respondent filed objections to the aforesaid application and prayed for its dismissal. When the application came up for argument, respondent filed a strange petition seeking transfer of the case by the judge Sumoto. So this is the whole story. Now, what are the findings of the court? Honorable Apex Court. It says that judicial function cannot and should not be permitted to be stonewalled by browbeating or bullying methodology, whether it is by litigant or by counsel. Judicial process must run its even course unbridled by any boycott call of the bar or tactics of filibuster adopted by any member thereof. High courts are duty-bound to insulate judicial functionaries within their territory from being demoralized due to such onslaughters by giving full protection to them to discharge their duties without fear. But unfortunately, this case reflects apathy on the part of high courts in affording such protection to judicial functionaries who registered through legal means a pressure strategy slammed on him in open court. So, giving these observations, Honorable Supreme Court listened to Arun Jaitley, learned Syrian counsel, who was counsel for the party. He made a plea before court that in view of what happened and also in the light of facts that appellant too had no objection to change the court, the case may be allowed to be transferred to another court. Now the law point before the Honorable Supreme Court was that if both the parties agree to change a court, whether it should be considered or not. So this court, that is apex court, give due consideration to the aforesaid plea in all seriousness, then said that we do not come across any valid ground whatsoever for a change of court. A change of court is not allowed merely because both sides have no objection for such change. It would mean that when both parties combine together, they can avoid a court and get a court of their own choice. We are not disposed to give such an option to the parties. We therefore refrain from acceding to the said plea made by Shri Jaitley. So, Honorable Court said that we direct the additional district judge, Tis Hajari, before whom the suit is pending, to proceed with it according to law, and appeal is allowed on these terms. So this is all about this case. Friends, you might be enjoying videos. If you feel that it requires more exploration, you are free to point out. I will oblige you as per my ability. Thank you for watching. God bless you all. Don't forget to subscribe, share, and praise or criticize. That's all.